This video will review the various IRS collections notices a taxpayer might receive, including IRS unpaid tax notices, balance due notices, important notice, the IRS urgent notice, IRS refund levy notice, the final notice, and the IRS intent to levy. In addition, there will be the IRS Notice of Federal Tax Lien filing and the IRS Statutory Notice of Deficiency. The 5 types of unpaid tax notices you've likely received from the IRS that may be causing you to research hiring an experienced IRS tax defense lawyer are an IRS Balance Due Notice, an IRS Important Notice, an IRS Urgent Notice, the IRS Refund Levy, and a Final Notice IRS Intent to Levy letter. Let's discuss them in more detail. A balance due notice on IRS Form CP-14 comes when you file a tax return without paying the proper taxes. With this IRS notice, all the government is doing is telling you what you owe on your recently filed tax return. If you, the taxpayer, don't pay or underpays, the IRS balance due letter will be arriving shortly, letting you know how much to pay and when it must be paid. This letter also provides instructions for how to make a payment plan if you are unable to pay the full amount owed to the IRS. You may be wondering, do I owe interest or penalties once I've received an IRS balance due notice? The good news is the answer is no. Not yet, anyway. If you pay the full amount owed by the due date listed on the IRS balance due notice, the IRS will not assess any penalties or interest on top of the actual tax owed. However, interest adds up after the date listed on the IRS balance due notice. Next, we'll discuss the important notice found on IRS Form CP-501. If you don't pay the taxes owed as shown in the balance due letter, the IRS very soon will send out what they call an important notice. The wording on the important notice will be very similar to that found on CP-14, except with slightly stronger language. You may be wondering, do I owe interest or penalties once I've received an IRS important notice? As you may have guessed, with this letter, the answer is yes. Interest will be tacked onto the outstanding balance until the taxes owed are paid in full. The IRS important notice will include a penalty section for your reference. But talk to your IRS tax problem lawyer to discuss how to remove these IRS penalties. If the taxes remain unpaid in about 35 days, you'll receive an IRS urgent notice. The urgent notice is found on IRS Form CP-503. The IRS sends out an urgent notice letter as another reminder that the taxpayer still owes the IRS money and that it should be paid within 10 days, or additional penalties and interest will start to accrue. If there's still no payment made on these taxes owed, the IRS will send out Form CP-504, also known as a refund levy. With the refund levy letter, the IRS is informing the taxpayer that they intend to levy and will begin searching for assets on which to issue a levy. A federal tax lien may also be filed to levy against the following assets: bank accounts, wages and income, business assets, personal assets, such as a car or non-homesteaded properties. Receipt of an IRS refund levy notice is not the time to bury your head in the sand. It's the time to reach out to an IRS debt lawyer right away. The final notice, or the IRS intent to levy, is found on IRS Forms 1058 or LT11. If you still haven't responded to any of the above IRS letters, the IRS will issue this final notice or intent to levy. At this point, interest and failure to pay penalties are accruing, and the IRS is about to commence its collections process. Letter 1058 or LT11 will advise the taxpayer of their right to appeal or a hearing. This is referred to as a collections due process hearing, sometimes referred to as a CDP hearing. This notice will be sent 30 days before the IRS actually commences any attempt to levy. If you've waited this long to get an IRS lawyer involved to help with your IRS issues, please wait no longer. You want an IRS defense lawyer to help appeal this matter at this point because the IRS will not levy while the appeal is pending. The Notice of Federal Tax Lien filing on IRS Form 3172 is sent out within 5 days of a federal tax lien actually being filed against the taxpayer. You may be wondering, why don't I get a final notice of the government's intent to file a tax lien as I might with a 1058 Notice of Intent to Levy? This is different than the IRS's Notice to Levy because this letter is sent only after the IRS has filed their tax lien. The IRS takes this position because they've already sent numerous letters letting the taxpayer know that they've been deficient in paying taxes. The IRS also views the filing of a federal tax lien as simply a protective measure, not an IRS collections action, since they don't actually do anything to take money from the taxpayer at this point. Filing the tax lien only protects the IRS's right to do so in the future. The IRS Statutory Notice of Deficiencies, also referred to as an NOD letter, a stat notice, or a 90-day letter. This is very important to bring with you to your IRS tax lawyer because it sets forth the IRS's position on what you, the taxpayer, actually owe to the IRS. An actual dollar amount will be provided on the IRS Notice of Deficiency. If you disagree with what the IRS believes you owe in taxes, the Notice of Deficiency provides that you have 90 days to file a tax court petition. When a tax court petition is filed, you don't actually go directly to tax court, usually. Rather, the tax court will likely refer the matter to the IRS Tax Appeals Division for handling by an IRS appeals officer. IRS Tax Appeals Division tries to get matters resolved to prevent them from having to go to actual tax court. An experienced IRS tax attorney can assist in this process. If you don't already have a tax attorney, please fill out one of the forms or call the number on your screen.